तो Google became abusive. It was easy for people to go and Hello students and welcome to another lecture, and the topic of this lecture is the evolution and implementation of intellectual property rights in India. The evolution and implementation of intellectual property rights. Intellectual property. We have had known different kinds of properties which are majorly classified into uh, physical properties, and the physical properties are further classified into movable and immovable properties, right? Movable and immovable properties, like if we can say that movable property is something that is mobile, that can be moved from one place to another. Immovable property is something which is fixed in its own place and it cannot be moved. It is not movable. Okay, so land is said to be an immovable property. We have different definitions of movable and immovable properties in the Transfer of Property Act 1882 and also the Sale of Goods Act 1930. So, in order to know what kind of movable and immovable properties are there, we should go and read property law. But there is another kind of property. And what kind of property is this? This is intellectual property. Intellectual property means, intellect means wisdom. इंटेलेक्ट मीन्स आपके आपके दिमाग की उपज, आपके दिमाग से जो भी आप चीज क्रिएट कर रहे हैं, योर क्रिएटिविटी, योर इनोवेशन, आप जो भी चीज क्रिएट कर रहे हैं आउट ऑफ योर माइंड, आउट ऑफ योर थॉट प्रोसेस, out of something abstract. Okay, thoughts are abstract. They cannot be touched. They do not have any physical existence, but they are there inside your mind, and those thoughts are working, and they are pushing you to do something which is creative, which is innovative. For example, if you are very good in science, you might invent something like Thomas Alva Edison invented bulb. Okay, and we have various other names in the field of science, where different big scientists have time and again discovered and invented so many things. It was possible only because of their thought process. It was only because of their intellect that they brought something into existence. Okay, this intellect, that if you do something, like for example, if you are a writer, if you are a thinker, if you are a philosopher, you might pen down a book. And if you are writing a book, that book is completely your work, which has come into existence out of your intellect, that is born out of your intellect. And once it is born out of your intellect, it becomes your property. Okay, obviously, intellectual property means anything that is created out of one's intellect is intellectual property. If you have penned down a book, and that book, the research behind this and all the content that it contains completely belongs to you, completely belongs to you. You are the owner. No one else can claim the ownership of that content. I cannot print a book written by you in my name. I cannot do that. This is known as intellectual property right. Okay. Then, for example, you might be a very good choreographer. You might invent your or innovate your own dance steps. And if you are innovating your own dance steps, that means those dance steps completely belong to you. You have certain intellectual property rights on those dance steps. If you are a music director, if you are a singer, and you have composed a new music, you own it. Okay, so all these things which you do out of your intellect, out of your talent, out of your mind, these are all intellectual property rights, because these properties are born out of intellect, and that is why they are known as intellectual property. I told you in the beginning that there are two kinds of properties, tangible and intangible. So this falls under the category of intangible property. Intangible means something that cannot be touched because it is a result of a thought process which is completely abstract in nature, and it does not have any physical existence. Okay, it belongs completely to the thoughts that are rotating and existing in your mind. Okay, so the evolution and implementation of intellectual property rights in India. Why it is important, challenges and perspectives are discussed here. Why it is important for any economy to grow, for any country to grow, for any community to grow, it is important that the innovations and creativity are encouraged to a great extent. And that is possible only when I get my appreciation. I get appreciation for any work that I do. If I am a scientist and I have done something, that I have invented something, and that needs appreciation, that needs to be appreciated, because that is not only my contribution, but that is a contribution for the entire country. The whole world will get to know that someone from India did something which is beneficial for the entire world. That is why these kinds of developments, research and development, is very important. And in order to ensure this creativity and innovation in every field, it is important that the intellectual property rights are guaranteed by law. Okay, which guarantee that inventors and creators are rewarded financially and socially for their efforts. If I'm investing my time, I'm leaving everything behind. I'm not earning my bread. I'm completely devoting myself to the research and development of the country. Okay, for example, if you have enrolled for a PhD program, so why does the central government has to pay you the scholarship? Why don't you in return pay something as a tuition fee like the way you do in bachelor's and masters? That is because the state is paying you because you are contributing research for the country. You are contributing something to the country, and the state is then paying you for this. You are leaving everything behind. You are not doing any job. You are not doing anything to earn your livelihood. You have a family. You have a family to look after, and still you are investing so much time in research, and that is going to contribute to the development of the entire country. That is why the state takes this responsibility or shoulders this responsibility to pay you the scholarship. Okay, so that is why financially rewarded and socially for their efforts, the intellectual property rights system in India has developed over time to offer complete protection for a variety of intellectual property types. An overview of India's intellectual property rights laws is given in this article, along with information on its development, historical background, legal importance, difficulties, issues, relevant legislation, enforcement, and important case studies. Now, the term intellectual property rights refers to the legal rights that protect works of literature, art, inventions, and legally exploited names, symbols, and pictures. The intellectual property rights framework plays a crucial role in India's economic development and competitiveness by promoting innovation and creativity and protecting the rights of enterprises, inventors, and creators. Patents, trademarks, copyrights, industrial designs, geographical indications, and plant variety protections are all included in India's IPR law, but problems with implementation, harm, and enforcement continue, necessitating a well rounded strategy to guarantee equitable access and safety. So, we have so many things. We have industrial designs, we have copyright. Copyright includes that if you have penned down a book, if you have written a book, if you have authored a book, if you have innovated a dance step, if you have composed a music, if you have done something literary, if you have written a novel, then then you own a copyright over it. Okay, then at the same time we have trademarks. Trademarks means if you are doing some business and you have a company and your company has a brand logo, that logo is trademark. Like for example, there are so many things. Apple has a trademark. You can see the sign of the apple, a button of apple. Then we have patents. Okay, then we have industrial designs, geographical indications. We are going to read them one by one. Historical context, origins and development. In India, the idea of IP originated in the British colonial period, the Indian Patents and Designs Act of 1911. That's very important. So, the Indian Patents and Design Act of 1911, which was the country's first patent legislation, established the framework for intellectual property protection in India. But the ordinance didn't provide complete protection for Indian inventors and innovators. Instead, it mostly benefited colonial interests. India recognized after independence that it needed a strong IPR framework to support its goals for development. अगर मुझे यही नहीं सिक्योरिटी है कि मेरा वर्क मेरे नाम से छापा जाएगा, अगर मेरे पास ये सिक्योरिटी नहीं है, ये मेरे पास गारंटी नहीं है कि मेरे जो काम है वो मेरे नाम से जाना जाएगा, तो व्हाई शुड आई डू, why should I do? At the end of the day, I would be needing some appreciation in my name. I would be needing the credit in my name. So that is where lies the root of ensuring access to IPR laws, right? Then coming to the Patents Act of 1970 was a landmark piece of legislation that focused on the public interest, especially in the pharmaceutical sector. It limited the number of product rights on medications in order to provide more inexpensive access to necessary treatments. Patents Act of 1970, it was a landmark legislation in the field of patents. Okay, and this piece of legislation that focused on the public interest. Patent means that if you are making something uh, with a particular recipe, okay, you have a certain fixed procedure to make something. Like you can take a very weird example. I know it might be weird for some of you. If you prepare a broth, जब आप कोई भी खाने की चीज पकाते हैं घर में, तो देखिए बेसिकली जो खाने हैं उन सब में मोर और लेस सेम रेसिपी होती है, बट कुछ स्पेशल डिशेस होती हैं, उनको कुछ स्पेशल लोग बनाते हैं, उसकी कुछ खास रेसिपीज होती हैं, कब कहाँ कैसे क्या करना है. दैट पर्टिकुलर थिंग रेसिपी इज नोन एज पेटेंट, कि ये हमारा पेटेंट है. कोई कोल्ड ड्रिंक बना रहा है, ठीक है, अगर कोई कोल्ड ड्रिंक मैन्युफैक्चर कर रहा है, तो उसका जो टेस्ट है और उसका जो कंपोजिशन है और उसकी जो बनाने का प्रोसीजर है, दैट इज पेटेंट. तो पेटेंट फार्मास्यूटिकल इंडस्ट्री में बहुत कामयाब रहा, क्योंकि जो कंपोजिशन ऑफ मेडिसिन डिफरेंट कंपनीज बना रही थी, दैट वाज वेरी इंपॉर्टेंट कि उसमें पेटेंट आए. Okay. Now, significance in the Indian legal system. IPR laws are important because they strike a balance between the interests of right holders and the public interest. The objectives of the legislation are to safeguard intellectual property, promote innovation, draw in foreign capital, and maintain equal opportunities for everyone. The IPR framework promotes technical development and economic prosperity by guaranteeing innovators and inventors the exclusive rights to their inventions. Okay. Now, concerns of IPR. Even with India's strong legal structure, a number of IPR related issues still exist. Implementation challenges. We have certain challenges, like in every field, we have challenges in this field as well. Okay. So, India has a lot of work ahead of it to properly execute its IPR laws. Significant backlogs are frequently caused by the prolonged and difficult process of registration for patents, trademarks, and copyrights. Once you will go through these acts, the Patents Acts and the Trademarks Acts and the Copyright Act, you will get to know how cumbersome these processes are. There's a lot of red tapeism involved in these processes in order to obtain one intellectual property right. So that's a very long process. You cannot get it because it is followed by a lot of cumbersome applications and procedures and all. Then effective execution of IPR rules is further hindered by enterprises' inadequate knowledge and comprehension of these regulations, especially in rural regions. For example, there are many industries which are working in rural areas, and the owners and the entrepreneurs in these rural sectors, they do not have a good idea about the IPR laws and their procedures. So they commit a lot of mistakes while doing it. Their lack of knowledge results in a lot of delay, and this further enhances the process of seeking an IPR on any particular thing. Potential misuse. Concerns are raised by the possible misuse of IPR rules, especially by dominant enterprises. Now, this is a phrase that I would like to take up in some other lectures separately. Dominant enterprises, you abuse of dominant position. There is a new law, Competition Act, and there is a new body called Competition Commission of India. Now, what is this competition? If there is a, there are some big sharks uh, somewhere in the sea, and what do? They eat up all the small fishes. जो बड़ी मछली हैं वो छोटी मछलियों को खा जाती हैं, चाहे वो तालाब में हो चाहे वो समंदर में हो. क्वेश्चन इज कि डोमिनेंट एंटरप्राइजेस जो भी हैं, जिनका एक मार्केट है, अभी हम एक बहुत ही लैंडमार्क जजमेंट है इसके ऊपर, कंपटीशन कमीशन ऑफ इंडिया वर्सेस गूगल एलएलसी, जहां पर गूगल के ऊपर ये एक्यूजेशन था कि उसने अब्यूज ऑफ डोमिनेंट पोजीशन किया. गूगल हैज अ डोमिनेंट पोजीशन इन द मार्केट. ओके, उसने गूगल मीट निकाला. क्वेश्चन वॉज के बहुत सारे अदर प्लेटफॉर्म्स थे जहां पर कोविड के टाइम पर वर्चुअल मीटिंग्स करने के लिए बेटर ऑप्शंस हो सकते थे, बट गूगल मीट ने निकाला तो गूगल बिकेम अब्यूज ऑफ. इट वाज इजी फॉर पीपल टू गो एंड स्विच इन टू द गूगल मीट बिकॉज सबके पास जीमेल अकाउंट है, सब जीमेल यूज करते हैं, सब गूगल यूज करते हैं, तो बड़ी आसानी से गूगल मीट पर जाकर वो बात कर सकते थे. क्वेश्चन इज कि डोमिनेंट एंटरप्राइजेस जो है वो बहुत मिसयूज करते हैं आईपीआर रूल्स का. For instance, patenting essential medications may result in excessive costs, making them unaffordable for the general population. Discussions about the moral application of IPRs have been triggered by the problem of evergreening, in which little changes to already approved medications are patented to extend their monopoly. Moreover, copyrights and trademarks may be abused to suppress rivalry or restrict freedom of speech. See, that is where, lot of disputes. This, once you'll get into litigation, you will get to know so many things about it. How? See, if you are, for example, using some music in the film industry, you can come and take that example. If you are running a show and if you are playing a song which belongs to another movie, a particular film director has composed that music, and a whole team of musicians is behind in the composition of that song. If you are playing that song without seeking legal permission from them, the person who owns it or the production house that owns it, you are going to violate the IPR laws. Then these kinds of disputes, they do arise in the field of IPR. A lot of disputes are there. Okay. Patenting essential medications may result in excessive cost, making them unaffordable for the general population. Like for example, अगर सारी दवाओं के कॉम्पोजिशंस को हम, हर दवा के कॉम्पोजिशन को हम पेटेंट कर दें, तो सिर्फ एक कंपनी जो है, ठीक है, जैसे फॉर एग्जांपल रैनबैक्सी है, रैनबैक्सी को हमने पेटेंट दे दिया कि ये दवाएं आप ही बना सकते हैं. तो अब ये बताइए कि अगर किसी एक बीमारी की दवा सिर्फ रैनबैक्सी बनाएगा तो रैनबैक्सी की तो मोनोपोली क्रिएट हो जाएगी. तो एक्सेस है, हम ठीक है लिमिटेड पेटेंट दे सकते हैं, लेकिन हर दवा पे पेटेंट देना ये तो ठीक नहीं होगा. ये डोमिनेंट पोजीशन में रिजल्ट करेगा, कि मोनोपोली में रिजल्ट करेगा, और इसकी वजह से सेपरेशन होगा. एक कंपनी बाकी कंपनियों को दबाएगी. अब ऐसा तो नहीं है कि रैनबैक्सी जो दवा बना रही है वो एमक्योर नहीं बना सकती, ऐसा तो नहीं है ना. तो ये सिचुएशन बहुत इंपॉर्टेंट है. देखिए ये इस चीज को समझना बहुत इंपॉर्टेंट है कि हर दवा को आप पेटेंट नहीं करा सकते. Discussions about the moral application of IPRs have been triggered by the problem of evergreening. Now, coming to law enforcement agencies, India's IPR laws are strictly enforced by a number of institutions such as the police, custom officials, specialized IP units. However, because of lack of funding, problems with jurisdiction, and the complicated nature of cross-border IPR infringements, enforcement is still difficult. Now, coming to judiciary, what is the role of judiciary? You see, judiciary has a very crucial role in interpretation of IPR laws and granting and recognizing the IPRs and settling of the disputes of the in the field of IPRs. That is not something new. IPR laws in India and its sections. We have the Patents Act 1970. It provides exclusive rights to patentees for their inventions. Key sections include these sections. We can read them. The Trademarks Act 1999 regulates the registration and protection of trademarks. Then we have these important sections. Then we have the Copyright Act 1957, and the Copyright Act, it protects original literary, artistic, musical, and dramatic works, as well as films and sound recordings. We have these kinds of important sections. Then we have the Industrial Designs Act 2000, which protects the unique visual design of products. Okay. Then we have the Geographical Indications of Goods Registration and Protection Act 1999. That's very important. Geographical indication. अगर कोई चीज कहीं पर खास बनती है, जैसे अलीगढ़ के ताले, जैसे मुरादाबाद का पीतल का काम, जैसे फॉर एग्जाम्पल केरला में एक पर्टिकुलर वैरायटी ऑफ राइस है, चावल, जो वहीं उगाया जाता है, उसको भी ज्योग्राफिकल इंडिकेशन मिल गया है। जैसे तिरुपति बालाजी के लड्डू हैं, वो मशहूर हैं। ठीक है। अब बहुत सारी ऐसी चीजें हैं जो ज्योग्राफिकल इंडिकेशन है, एक खास जगह से कनेक्टेड है और वहीं की वो चीजें मशहूर हैं। ओके। Protection of Plant Varieties and Farmers' Rights Act 2001 provides protection to plant varieties and recognizes the rights of the farmers. Okay. Now, एक बहुत important cases है Novartis AG versus Union of India. This case is a landmark judgment on the patentability of pharmaceutical inventions. The Supreme Court rejected the Novartis patent application for its cancer drug Glyvic because it did not meet the requirements of novelty and non-obviousness under section 3D of the Patents Act. See, novelty, कोई नई चीज हो आपके पास तभी पेटेंट मिल सकता है। अगर नॉन ऑब्वियसनेस हो, उसके अंदर नॉवेल्टी हो, तभी वो पेटेंट मिल सकता है। अगर नॉवेल्टी नहीं है, कोई नॉर्मल चीज आप बना रहे हैं जो बाकी सब बना रहे हैं, तो उसमें पेटेंट क्यों मिलेगा? तो नोवार्टिस की एप्लीकेशन को सुप्रीम कोर्ट ने रिजेक्ट कर दिया। Monsanto Technology LLC versus Nuzivedo Seeds Limited. This case involved the patentability of genetically modified seeds. The Supreme Court ruled that Monsanto's patent for BT cotton was valid, but Nuzivedo seeds could continue using the seeds under a license agreement. ठीक है, तो इसमें ग्रांट कर दिया था, रिकॉग्नाइज कर दिया था। Then Yahoo versus Akash Arora and another. This case addressed the trademark infringement in the context of domain names. The Delhi High Court ruled in favor of Yahoo, holding that domain names can be protected as trademarks. The case set a precedent for the protection of digital trademarks in India. So that's how we have the entire legal framework to protect and promote intellectual property rights. That's all. Thank you.